5, 4, 3, 2, 1.
Oh yay, oh yay, oh yay. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court.
Thank you, Ms. Kraft. And on behalf of Judge Stafford and Judge Bennett, we welcome counsel and are thankful that we can participate in this live streaming oral argument. We will conduct the hearing in the same manner as if all of us were together in the courtroom. Each of you have 15 minutes for your argument, and Ms. Alexis has the right to reserve time for rebuttal, and I understand she has already informed the clerk of that amount of time. Unless there are announcements, I'll ask Ms. Kraft to call the case.
Carolyne Payne versus Maxine Bradley.
All right, Ms. Alexis, you have the floor.
Good morning, and may it please the court. My name is Tuska Alexis, and I'm appearing on behalf of the appellant in this case. This case, as your honors are aware, concerns a contract that the parties entered into in March of 2013. The agreement between the appellant and the appellee here was prepared by an attorney, and it was prepared by appellee's attorney, and the agreement reflects the intent of both the appellant and the appellee to equally share in the cost of pursuing a lawsuit that was filed in Chancery Court against the appellee. The agreement laid out what the parties would do. They would share in any and all expenses of that real property, including property taxes, the upkeep of expenses. And at the conclusion of the lawsuit, if the appellee won, the property would be deeded in both the appellant and the appellee's name. The contract provided that if the appellant failed to pay her share of the expenses and cost and any of the upkeep of the property, then the appellee would not be required to deed her 1/2 of the property to appellant. Well, what happened in this case, the appellee failed to cash a check that the appellant sent to her. And the evidence that was presented in a trial court showed that once she was advised of those expenses, she forwarded a check. However, appellee failed to cash that check and consequently told the appellant that it was a breach of contract. The appellant then sent another check after tracking the letter that she sent and the check that she sent, and found out that it was indeed received by the appellee. The appellee in this case then received the check and refused to cash it. After she failed to cash it, she claimed that appellant had breached the contract. The appellant is taking the position that the case should be reversed because it's clear here that the parties entered into an agreement. The appellee and the appellant performed under the contract for several months. The appellee gave the appellant all the related expenses. The appellant paid her share of the expenses. She paid $400 in December. She paid another $250, another $850. And there was several other payments in the amount of $250, $225. And final check was the check that would wrap up the expenses in the case. And that is the check for $2,204 that the appellee indicated she never received. And in addition, she indicated that when she did receive it, she did not cash it. I believe based on the evidence that was presented at the trial court, the plaintiff, who was the appellant, performed all the obligations that were required of her under the terms of the agreement. But in February, after the appellee discovered that she had won the case in Chancery Court, she decided that she would not accept the payment and indicate that the appellant had breached the contract. And so when the appellee performed under the contract, she paid all the monies that she was supposed to pay. She did everything that she was supposed to do in performance of the contract. And respectfully, I believe that the defendant, the appellee, materially breached the contract. And it is a position that because she breached the contract, she should be ordered to give the appellant 1/2 of the real estate as she promised that she would in the event that she honored her portion of the contract. Your Honors, the contract here is in writing. It is a clear contract. It was signed by both the appellant and the appellee, and there was adequate consideration. In fact, not only did the appellant pay everything she was supposed to pay, she performed under the contract and she appeared willing and able to perform under the contract until the defendant's refusal to accept after winning the case in Chancery Court.
Well, didn't the trial court say that the contract was unenforceable because it was unclear as to when these payments were due?
That's correct. However, it is clear when the payments were due. The payments were due upon completion of the case in the Chancery Court. And in February, the decision came down in February of 2015. Initially, the case was heard in November of 2014. And so if we're looking at the terms of the contract did say that at the conclusion of the lawsuit, and if the appellee won, the property would be deeded in both the names of the appellant and the appellee.
Counsel, let me ask you a question, please. You say the terms of when the payment were due was clear, and where do you find that?
In the agreement, Your Honor, the agreement that was entered into between the parties in 2013. And in that agreement, the agreement stated that at the conclusion of the lawsuit, the property would be deeded in the name of both the appellant and the appellee. So the lawsuit—
I think you're misunderstanding my question, or perhaps I didn't state it correctly. Where do you find the terms of where your client was supposed to pay the expenses of the lawsuit? Is that contained in the agreement?
No, it is not contained in the agreement. In the agreement, it states that the agreement was made to share equally in the expenses, the cost of pursuing the lawsuit, and all expenses regarding the property in question. And so it does not state that. However,
So how do we know then when those payments would be due?
Well, I believe we know when the payments are due based on the appellee notifying the appellant, because from the conduct of the parties, each time the appellee notified the appellant that she had to make a payment, she did in fact make a payment. And so I believe based on if we're looking at the contract, it would appear that the appellee would notify the appellant of payments to be made. In fact, she took her with her to the attorney's office when a payment was made. She took her to court with her on numerous occasions, and in fact told her that some of the costs associated with the lawsuit in Chancery Court was not due and she did not have to pay it. But ultimately in February of 2015, when she did advise her that she had to make that payment, she in fact sent the payment. So I believe from the intent of the parties can be looked at by the conduct once they entered into that agreement, but it is not stated clearly. That's correct. So respectfully, I believe there was no duress. I believe that the contract here appears to be clear. There's no fraud, there's no unfairness. It was signed by both of the parties, and in fact prepared by the appellant attorney when she was dissatisfied with the first contract that was presented to her. She indicated her dissatisfaction and wanted the contract redrawn. Once that contract was drawn by the attorney, appellee signed. And so based on that contract, I believe that appellant's position is that it should be specifically enforced. And based on that, we believe the decision of the trial court should be reversed. In addition, there is an issue of
Alexis, your initial time is up, but we'll hear from you further on rebuttal. Ms. Redpath, your argument.
Thank you, Your Honors, and good morning. May it please the court. My name is Carolyne Redpath, and I represent Ms. Maxine Bradley. This is not a case where the parties disagree on whether there was an agreement, albeit an enforceable one. The disagreement on whether or not Ms. Carolyne Payne actually breached the contract prior, when she stopped providing the support that she had promised she would. As Your Honors are aware, the terms of the contract state specifically that at the conclusion of the lawsuit, the property be deeded in the name of Maxine Bradley and Carolyne Payne. But if Carolyne Payne failed to pay her share of expenses, costs, and upkeep of the property and or taxes, Maxine Bradley would not be required to deed 1/2 of the property to Carolyne Payne. This was the agreement between the parties. This is what they signed. Now, this lawsuit that was brought against Ms. Bradley was something that she had to seek assistance for. That's why she went to her sister, Ms. Carolyne Payne. That's why she said, I don't want to have to dip into my retirement funds. I don't want to have to go through this alone. I think I might need some help with this. And at first, her sister agreed. Ms. Carolyne Payne agreed, provided that she had some share, some interest in this. And so they wrote up this agreement with an attorney present where this, because of the support, because of the upkeep, because of Ms. Bradley not having to dip into her retirement savings, she would agree that at the conclusion of this lawsuit, provided she won, that they would split this property equally. But a couple of months into this lawsuit, which lasted for 2 years, Ms. Carolyne Payne stopped any financial support. And in fact, she never provided any financial support in regard to the taxes or the upkeep on the estate. Ms. Bradley shouldered. Your Honor, I'm sorry, could you repeat the question?
Was she told she needed to make these tax payments?
Your Honor, it is Ms. Bradley's stance that she repeatedly asked her sister whether or not she could pay these, that she repeatedly requested payments of this. In fact, the trial court heard evidence of such by both sides. Now, it is the other side's stance that, oh, well, she never knew about this. She was never aware of this. But by her own testimony, she did admit to the trial court that she attended multiple meetings with the attorney during that 2-year period. In fact, she was even there on November at the final trial date, where she did hear the judge's final order. In fact, Ms. Carolyne Payne was just waiting to see whether or not her investment would pay back without ever having to provide the initial support that she had promised.
Did the trial court make a finding? I know the trial court found both witnesses to be credible, but did the trial court make a finding that she had been requested to pay the taxes and insurance and that she failed to do that?
I do, Your Honor, no, I do not believe that the trial court made a finding of whether or not there were formal requests, or I believe that they found both witnesses' testimony credible. But
So if that is the case, then what is the breach?
Your Honor, any breach of contract, our stance would be that it was by Miss Carolyne Payne by not providing the support that she had paid during the time in which she was supposed to be providing it. There was a 2-year legal battle during which time she had said, I'll provide upkeep on the cost of the house. I'll provide relief on the taxes of this. I'll provide legal support for your attorney's fees, your court costs, anything associated with that. And she didn't. She did it for 3 months, and then for the remainder of those 2 years, provided nothing.
I understand that's your position, and I understand that the trial court held for you. What I'm trying to ascertain is the trial court found there was an agreement, but the agreement was not fulfilled. How was the agreement not fulfilled? Was it because generally there's no payment schedule, but at what point in time did your client request payment that was not made? And was that found specifically?
No, Your Honor, the trial court did not find that specifically. The trial court looked at the lack of a payment schedule, found that that made it unenforceable, and in their writings went no further into whether or not one party or the other was in breach because of it. It did note that should there be some sort of payment schedule, that there still would be a lack of payments of any taxes or upkeep on the property, even with the money, even if there was a payment schedule within the realm of while the case was ongoing, even if at the close of the case, she could provide that money. Miss Carolyne Payne did not. She did not, at the final court date where she was present, say, okay, let's wrap this up. I know this is going to be successful. Let me make sure that any costs that you've shouldered, anything that you've had to dip into your retirement savings for, let me make sure that we're all squared away so that we're making sure to hold up our sides of the contract. No, she waited.
Okay, before we leave this, the trial court then implicitly did find that a request had been made for payment of taxes and insurance, because you just said that that request, she didn't make those payments. So I'm assuming that the trial court credited your client's testimony that that request was made. Is that accurate?
Yes, Your Honor.
Okay. All right. So I'm struggling with the fact that the trial court found this was an enforceable agreement, but then determined it was unenforceable because there was no payment schedule, and then didn't necessarily find what request for payment had been made that were not made. That's not a good way of saying it, but anyway, the payments that had been requested that were failed to be made. So
Well, Your Honor,
could you enlighten me any there?
Well, Your Honor, to go further with what you're asking about, one of the things that Ms. Payne is asking for is for specific performance. And the trial court's decisions on finding that there was an agreement, but that it is not enforceable by the court because the terms of which were too ambiguous, with there being a lack of payment schedule, too ambiguous in order to enforce specific performance, which is what Ms. Carolyne Payne was asking for. Now, to overturn that decision, as the court is aware, in Hiller v. Franklin, the decision of a trial court to specifically order performance lies in the trial court's discretion and should not be overturned unless there was an abuse of that discretion. And it is our stance that the appellant has failed to prove that there was any abuse of discretion. The appellant has made a lot of statements of what they believe or how they think that the court should have decided, but the standard of abuse of discretion is not one, I know your honors know, that is easily found just because of a belief or a feeling of, oh, I think it could have gone this other way. The trial court looked into the evidence. The trial court gave multiple opportunities for Ms. Carolyne Payne to organize her evidence, to get fact witnesses, to answer discovery. There were multiple extensions granted from both sides. This was an ongoing, long-held legal battle. And at the end of the day, the trial court did hear evidence from both sides, heard the credibility of the witnesses, saw the agreement in question, saw any other evidence submitted to the court, and chose to say, this is, there was an agreement. Without a pay schedule, we can't say that we're going to specifically enforce that she deed half this property to you. And appellant has failed to meet the burden of an abuse of discretion standard to overturn that decision.
Well, let me pose one more question to you, and I don't want to monopolize all the time, but you've got a situation where some payments were made, correct?
Yes, Your Honor.
Initially. Payments were made, request for payment, payment made, nobody's complaining. So you've got at least some performance. You've got a course of dealing here under this contract. The analysis, well, and I haven't been through the record, so I'll say that on the front end, but the analysis to me seems lacking because you've got a course of dealing, you've got some partial performance in any event, and then you've got a statement by the trial court that the contract is unenforceable because it lacks a specific or lacks a essential element. I'm wondering how that all needed to be analyzed or should have been analyzed by the trial court, because there's no question there was a partial performance up to a point in time when it wasn't performed anymore for whatever reason. And I can't, other than this implicit finding that Judge Bennett mentioned earlier with the taxes and insurance, that what that failure to perform was. It's not a specific finding that a breach occurred at that point in time that threw it off the tracks. So do we have enough information in the record? Do we have sufficient findings for this court to review at this time?
Yes, Your Honor. There are sufficient findings by the court. And I will clarify one of the things that you brought up just now. You mentioned a course of performance between the parties. The trial court did not find, oh, there was a method of Miss Bradley requesting these payments and Miss Carolyne Payne then responding in kind with her payments. Miss Bradley's position was and still is, Miss Payne attended these conferences with me. She attended these meetings with my attorney. She was aware of all of these costs. And at the beginning, she was choosing to help pay them. And then suddenly she stopped. Even after I requested, I started having to send a request because she was refusing to support them, even though she was there at every single one of these meetings, there at every single one of these hearings. And she was aware that I was having to shoulder these costs alone. Miss Bradley's position is not that she requested them.
Here's my problem with that finding, though, or with that, your analysis of that. The trial court found both parties to be credible. And as I understand it, the trial court did not find, as you are suggesting, that yes, she was a participant all along. She was at the meeting. She understood the payments had to be made, and she just failed to make the payments.
Yes, Your Honor, but by her own testimony. If you go back in the record, you can see Carolyne Payne's, the transcripts of her depositions. Her own admissions is that she was there at multiple attorneys' meetings, that she was there.
Did she agree that the payments had to be made, or that she understood that the payments had to be made at that point in time, though?
Now, Your Honor, I can't speak to her knowledge, but she's given a bit of
did she make an admission in the deposition or in testimony that yes, I was at those meetings, and yes, I understood the payments had to be made, and I just didn't make them?
Your Honor, she has said one and half a dozen one, half a dozen the other. She has said, I was aware that I was supposed to be doing this. No, I was never told. She has said, I was there for all these meetings, but then she has tried to say, oh, but Miss Bradley should have been telling me when things were due. She said, oh, Miss Bradley did tell me sometimes. And then another time she said, oh, well, I never knew about this. She's admitted to such, but then she's also contradicted that at points in her testimony.
Okay.
Well, the trial court never came out and said her failure to pay some of these other expenses was a breach because he couldn't decide when those payments were due based on the document, right?
Yes, Your Honor. There was no finding of a breach of contract. Your Honor, our main argument today is we're not here to argue whether or not there was a breach, at least not from our side. We're here to say whether or not the trial court correctly or incorrectly made its decision. And we believe that the trial court, in doing so, more than just we believe, but the law says that the standards of which to overturn the trial court's decision are much higher than that the appellant can reach today. The appellant has not shown any proof of this. Your Honor, I see that my time is about to expire. May I conclude?
Please.
Thank you, Your Honor. The issues raised by the appellant in this are not those of any issues of substance or fact. Rather, it's merely just another extension to draw out time and expense against Ms. Bradley. And as such, we would ask that this appeal be dismissed, and we ask that the cost of having to, again, come and defend such would be awarded to Ms. Bradley. Thank you, Your Honors.
All right. Thank you, Ms. Redpath. Ms. Alexis, your rebuttal.
Yes, Your Honor. Respectfully, the time and expenses are on also the appellant side. Your Honor, the evidence at trial is clear that the parties had a telephone conversation in February of 2015, right prior to the court in the Chancery Court making a ruling. And at that conversation, the appellant was told by the appellee that there was a remaining $2,000 to pay. And that amount was indeed advanced by the appellant. Then the issue became, well, I didn't receive the mail. And I didn't receive the mail because I didn't know you had sent anything, and I didn't have that conversation with you. However, the testimony showed clearly that the parties spoke every day, and that during that time, just before the ruling came down, they had that conversation, and the amount that should have been paid to wrap up this case was indeed spoken about during that conversation. And that is when appellant sent that $2,000. The appellant here also contends that she was never told of the upkeep of the property. She appeared in the attorney's office, the second attorney that was hired by her sister, the appellee, and they spoke about everything, but never spoke about the fact that that the appellant was owing anything or that she had to pay anything. In fact, she was told that she did not have anything to pay. Counsel made mention of the fact that everything was ready for trial, that fact witnesses were done, discovery was done. However, appellant did file a motion asking for the case to be continued because she had not conducted meaningful discovery, that she was representing herself during the discovery phase. And that case was not even, that motion was not even heard. The special master heard it at a telephone conference and indicated that the case would be proceeding to trial. And that was one of the issues that appellant raised, the fact that she asked for a continuance, that the appellee was not opposed to a continuance, And in fact, there was not an order entered to that effect. In addition, on the day of trial, appellant made a motion to the court for another continuance, and the court indicated in the record that they would prepare the record and prepare the ruling in this case. However, the court did not once mention the fact that appellant had raised the issue of requesting a continuance. So contrary to what counsel is saying, that case was not prepared for trial, and appellant indicated to the court on 2 occasions in 2 motions, one 3 weeks before the trial and one on the day of trial, and the court still proceeded and heard the case. Appellant respectfully requests that the decision of the trial court be reversed on the issue of the contract, and also on the issue of a continuance being granted to the appellant so that she could be prepared for trial and that she could advance her arguments successfully. So respectfully, the appellant requests that the decision of the trial court be reversed.
Thank you, Ms. Alexis and Ms. Redpath, for your arguments. We will take this matter under advisement. Ms. Kraft?
The Honorable Court of Tennessee is now in recess.